591DP. This time of day is set for motion hearing. Ms. Heron filed a motion regarding parenting time. She is in the courtroom. She's in pro se. Mr. Williams is present, represented by Attorney Dennis W. Reed. Will both parties please raise their right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yeah.
Yes.
Thank you. Ms. Heron, you may proceed.
Well, I want to see the ex. I haven't seen him in a year and a half, almost 2, for some issues.
What issues?
They were taking CPS back in 2023, 2022. I was seeing him supervised for a while. West stopped the visits. I got him back. 3 weeks later, my son was murdered. I'm taken away again, and I haven't seen him ever since.
Is the child still with father?
He's been with father since they were taken the first time. He was taken the first time.
I'm assuming there's a companion case, a petition in another county, correct?
It's Huron County. The ex was dropped off of it. The other 3 kids are returning home by the end of April. And ex was.
But that's not been ordered yet.
Yeah, the order is right here. He signed it and made it.
Who's she?
Nancy Fain?
Judge Thane?
Yeah.
Anything else for me to consider?
No.
Judge, I filed a fairly lengthy response and a supplemental response. I received a letter yesterday from TAPS, who has been counseling the child for the last 16 months. I'm handing a copy of that to mother now. I just received it yesterday during the noon hour and sent it up to the court for consideration. There is a lot here, and I touched on it in my response. This case goes back to an Oakland County CPS case that was opened in 2023. And the child in question here in this case was removed from mother's care, I believe like maybe at the end of 2022. And then in February of 2023, my client came before the court and the parties worked out an agreement, and he was granted full physical custody of the child with joint legal, no parenting time unless it was approved, so to speak, by the Oakland County Child Protective Services Agency in the court down there. They did, and she was granted 1 hour supervised per week, initially up here and then down in Lapeer County for a while. And then in October of 2023, mother apparently wanted to have her boyfriend, whose name is in the court file there, participate in the visitation with this child. Why, I don't know, but my client opposed it, and CPS out of Oakland County didn't do anything further, and she never saw the child again. And then I understand sometime after that, the children were returned to mother, but this child remained with father under this court's order. And about 2 weeks later, her boyfriend, who she wanted to have come for visitation with this child, ended up allegedly murdering their very young child. According to what information we have, that child was beaten to death, 17 fractures, and died apparently at home. The child had been left in the care of that gentleman by mother. Again, we're getting this secondhand because my clients can only go so far into that matter himself. But mother,
was there a plea entered?
No, that's how I get to it.
Okay.
During the investigation, we're told, and I haven't verified this yet through the copy of the police report, but we're told that mother told the detective that she didn't trust this gentleman, the man that killed her child, and yet she left this child with this gentleman. So there's things going on here. There was a plea offer made from what I've been able to track down to this gentleman over in Tuscola County. He rejected it. And there's, from what I've supplied to the court, that's a public record, there's a trial scheduled for April 15th on open homicide charge. So feasibly, he's facing maybe the rest of his life in prison if he's convicted of that, unless he is able to work out a plea bargain in the next couple of weeks here. We would like this motion, basically nothing done with it right now until we see what happens here with the reunification, with the outcome of this jury trial, and what mother's involvement really was in that whole situation that ended up in the death of her very young child. We don't know. We have bits and pieces that Child Protective Services has provided to my client, but as not being a party in that case and his child is with him, the information is pretty bare bones. I've told you basically what we believe to be the truth here on this. So I'd ask that the motion be denied at this point. I was able to get a hold of the counselor. It unfortunately took several days to get a response, but you can see.
But it is hearsay.
It is. I realize that, Judge. But I think it's important in this regard. The child has been with this counselor for 16 months, not just a few days or a few weeks, you know. She's been counseling this child for 16 months. And she is against any contact at this time with mother. And so if the court wants to proceed in some fashion with this, in light of all of this stuff, I'd ask that it be referred in front of the court, let that office investigate it properly, and they have access to a lot of the stuff that we don't. And they can get the police report, they can get the CPS reports, and they can find out what's going on here exactly. And then make a recommendation on where we go from this. But this is one I think we need to be very careful with. Mother hasn't seen this child, and from what I understand, hasn't even made any effort to see this child since October of 2023. That alone is enough right there to slow down the process of reunification of mother. This child is not involved in the reunification plan that's supposedly underway over in Huron County. I don't know why. Seems like it should be, but it's not. And it appears to me, just looking at it as a bystander here, that agency is doing nothing because this court has the jurisdiction over that child and can do whatever orders it wishes. Child's protected at this point in time. I think everybody will acknowledge that. There's nothing wrong with my client's home. My client wants to proceed very cautiously with this until we find out more of this information and we see what goes on with the reunification. Because this is not the first time mother has had reunification with her other children and failed. Just in the last 2 or 3 years. And so now we're going to want to throw this child back into this mix, and maybe it'll work, maybe it won't. We're talking about a very young child here who has had some problems here, and I think that's exhibited in the TAPS letter. I know it's hearsay, but I think the court can take some notice of that there's ongoing efforts to deal with the troubling experiences that this child has had in its life. Do we risk then sending the child home for a third time? And here we are again, a mess. So I'd either ask the motion be denied at this point or referred to the front of the court.
Thank you. Anything else?
No.
Yes, go ahead.
I mean, I see where they're coming from, but the criminal case has nothing to do with me. I have tried to see Xander. Even in Ab Close, when they did come home, when the other kids came home, January 29th, I was like, any way we can talk about seeing Xander, and the only way he would let me see Xander is I'd give him full custody of everything. Like, I have the paperwork stating that. So I have tried to see Xander, and when the other kids were taking the last time, my hands were tied. Because if he didn't come to if he didn't bring him to the supervisor, then I couldn't do nothing about it. Because they had jurisdiction. And the only reason why he's off the case is because Mrs. Thane, Judge Thane, thought it was because I haven't seen him, just to drop him off the case because the other kids are coming home and then to come up. She told us all prior orders remain in effect. So all prior orders, I have to come back to this court and get visitation, parenting time. I'm not asking, I mean, even if it's for a couple hours. I mean, I know I haven't seen him in a while and I get that, but you can't use a criminal case and my baby daddy on me.
Thank you. I respectfully beg to differ. Now I understand what this is involving. And this is a pending matter in Huron County. I believe it's an open murder charge.
Yes.
Regarding the other child. And the child is with mother and this individual at the time. I'm not going to consider the letter because it's hearsay. We would need testimony from the therapist regarding that. However, as it pertains to the motion right now, I find it, because again, the court has to find the proper cause or change in circumstance to review this. And right now, I think it's not right yet for the court to review because there's the pending criminal matter. And I'm hearing allegations that, and again, allegations, because nothing's been established, but allegations that Ms. Huron didn't trust this individual that left the child. And as far as the court's concerned, when it comes to behaviors on behalf of one child, that shouldn't be any different for the other child. So I find this motion to be prematurely filed after the criminal proceeding. It might be at that point in time, once all the smoke clears, and it sounds like April is the trial date. Anytime after that, I think would be more appropriate for this motion to be heard. But as of right now, it's not the appropriate time. I respectfully am denying the motion in this case.
Thank you, Judge.
Yes. This is the defendant's motion regarding custody and parenting time. Mr. Costello is present, represented by attorney Jessica S. Risky. Ms. Soroka is in pro se. Prior to going on the record, the court called the case and asked about the pronunciation of the defendant in this matter. And the reason the court asked is because a number of years ago, I'm probably talking about 10 years ago, the defendant's mother was a service provider for our family regarding our family pet. So I'm just placing that on the record. Also placing on the record that a number of years ago, I represented Mr. Costello in an unrelated proceeding, probably talking at least 10 years ago. No longer than that, probably 13 years ago.
Yeah.
13 years ago. So I'm placing that on the record so that everyone understands that when the court is to consider a motion like this, I am not favoring one side or the other because of the fact that I had a relationship a long time ago with the defendant's mother. By the way, I'm sorry to hear of her passing, but also to the representation that I had of Mr. Costello well over probably 13, 15 years ago. Mr. Roca, is there any problem with the court hearing this?
No.
Appreciate that. All right. Both parties, please raise your right hands.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Ms. Risky, you may proceed.
Your Honor, I'm just going to help your standings.
I appreciate that.
Just a lot easier for me. As I had detailed in the motion, the court had entered an order back in February of 2024, so it's just been barely over a year. And in that last year, we have had so many issues. My client has tried over and over and over to co-parent, to assist. I mean, he has gone above and beyond paying her car insurance to make sure she's got an insured vehicle for the minor child, to allowing her to move back in because she's bouncing around from home to home and boyfriend to boyfriend.
Moving back in.
My client allowed her to move back in August of 2024 to his home with a minor child because she was effectively homeless.
How long did that period last?
She just moved out not even a month ago.
Okay.
About 3 weeks ago.
Okay. Go ahead.
With another significant other. There's been hospitalizations on and off of medication. Even on her parenting time, she's pawning the child off on dad, grandparents. She has been completely inconsistent the entire time since the last order of the court. And for minor child, you know, consistency is key. She needs a safe, stable environment, and she needs parents who are going to be able to provide the proper care for her. If she has a mother who cannot be trusted to take her mental health medication and then therefore is having issues dropping the child off, I can't take care of this child, I don't want to see this child, and then having to be hospitalized, that's a risk for safety. She is unable to hold a job, I think more so unwilling, and so that is why we are seeking that my client be awarded the sole physical custody and that parenting time be every other weekend for her year round, and holiday time pursuant to the Huron County Front of the Court guidelines. I understand that she's been told her, but she has failed to file an answer in any way, shape, or form to the court, to my office. We're not opposed to, you know, a front of the court investigation, because we don't argue that at the time that this was all said and done back then, there was hope that they could co-parent and things could go well. And my client has tried repeatedly to assist her, but if we just allow this to continue, at some point, this minor child is going to suffer irreparable harm. So, again, we would be opposed to that if that's what the court wishes to do, and if that's what the front of the court thinks would be appropriate, but we would ask in the meantime that my client be granted temporary sole physical custody per every other weekend, and, you know, pending, you know, that recommendation.
Thank you. Ms. Roca, your response. Please stand when you address the court. Thank you.
Your Honor, I am not a perfect mother, but I am a trying mother that also wants full custody of my daughter due to her safety, well-beings, because there has been rules that we have been through with you in the court that we determined back in 2022. And some of those rules got broken, and it is all on the court app. I have video, text messages of proof that on me, because I did not know what the lawyer was going to argue with today about. I'm a trying mother. I'm not perfect, but I'm there for my daughter when I can possibly be, when he allows me to be there. Because sometimes he will put it over my head and not allow me to see my daughter when it's his time, and I understand that, but I even try to be there for her on his time too. I have done shots in my stomach when I was pregnant with her because of blood clotting issues. I did more appointments when I was pregnant with her. I did everything a mother should do when I was pregnant with her. I ate a lot, you know, I took care of myself when I was pregnant. I had put her in MSU testing for autism because we suspect autism, and that was my idea. Mr. Costello didn't think it was really of an issue until I had to multiple times tell him we need to do this for her well-being. I have put her in a STAR program, speech class. I have done a lot for her, and there has been times that he has forfeited his time, and you can see that on the court app. I mean, I'm not a perfect mother, but I'm a trying mother that loves her daughter, and I would like full custody too, just because.
But you've not filed a motion.
I have not.
And you've not filed.
Because I've tried to do the 2-2-3 like you wanted us to do, and I've been trying to co-parent with him for the past 2 years, and he's made it feel very impossible and has not been fair, and he has currently forfeited 2 days so far, and he has used excuses of why he forfeited, which if it's his parenting time, he still needs to watch her, and I don't mind helping him, but when I've helped him and he's used that against me, saying that I have forfeited my time. So, I mean, I can only help him to a certain amount. So why give him custody, full custody, or whatever he wants when he still needs my help? His mother has passed away, And I think more now than ever, Brielle needs both of us. And I've always put her before myself. That's why she's in his STAR program, speech class. She's getting tested for autism. I've made for sure when she's sick, she has everything that she needs. I tell Brent that this is what she needs. You know, I'm sorry that I need your help financially, but I can't do it as a single mother all by myself. But I'm trying, Your Honor.
Okay. A question for you though, and then Ms. Risk, you have the ability to question you as well. The 223 arrangement, that wasn't what the court wanted. That was agreed to between you and Mr.
Yes,
Costello.
yes, yes.
So it wasn't a matter of the court wanting you to do that.
Yeah, we were
That's what
trying.
you agreed to.
Yeah, we were trying to do that, and Mr. Costello recently has been breaking that rule, and he's also broken another rule, part of our agreement, and that is drinking on his parenting time. And there is proof on the court app that he admitted to drinking on his parenting time.
Where are you currently living now?
I am living with my current boyfriend in Owendale, and we have a house that is perfectly safe for her and is baby-proofed. And she has food there, and she has a room, and she has everything that she needs.
Okay. Could you please step up to the witness stand? Ms. Risky, you may question.
Ms. Rokel, when did you move to Ondale?
Approximately roughly 2 weeks ago, 3 weeks ago.
But prior to that, you were living,
With Mr. Costello.
yeah, so you were living with him, and you would have been living with him for approximately 6 months, correct?
Since roughly August.
And where do you work?
I'm currently
Where was your last place of employment?
Tower Kentucky.
Okay, when was that?
I quit in November.
All right, how long did you work there?
I don't
You know when you started there?
remember.
Okay, so were you working there in August when you moved in with Mr. Costello?
I don't think so.
What was your prior job before that?
I don't recall.
So in the year of 2024, how many months would you say you were employed?
I don't recall.
You don't know how long you worked at all?
Well, I've been staying at home taking care of my daughter when Mr. Costello was working and doing overtime.
How do you pay your bills?
I have Mr. Costello used to take care of it.
Now, you had mentioned earlier that Mr. Costello will stop you from seeing your daughter, true?
Yes, sometimes when it was his parenting time and he was upset with me and I wasn't helping him with parenting time.
And when was this?
Back when I was living with my ex-fiance.
And when was that?
I don't know, maybe a year ago, 2 years ago.
Okay, so that was
A year and a half ago.
a year and a half
I
ago.
don't really recall.
Okay, so I'm referring to everything that's happened since February of 2024. So in February of 2024 to now, how many times has he denied you parenting time?
I don't recall. That can be looked on the court app.
Well, you do understand that today is the motion hearing, so you should bring those types of proofs with you, true?
Well, Your Honor, I didn't know.
I'm not your honor, that is
My
his
bad.
honor.
It's okay. Anyways, I did not know what we were gonna be discussing. I thought this was gonna be short.
Okay, so, and you're trying to mention that you've attempted to co-parent with him, and you're referring to since February 1st of 2024, true?
Repeat that again?
You had mentioned that you had difficulties with co-parenting with him.
Yes,
Were these difficulties from,
since she's been born.
I'm not talking about since you've been born, I'm asking specifically if it was from February 1st of 2024 on.
It's been difficult for almost 2 years.
So if it's been so difficult, why did you move back in with Mr. Costello?
Because I wanted Brielle to have her father in the picture and I wanted to be civil for both of us and try to maybe get our family back together.
When has he ever not been in the picture?
There has not been a time.
Now, you were hospitalized back in December of 2024, correct?
Yes,
Okay, so how long were you hospitalized for mental health issues?
a week.
Okay, and upon your release, instead of going to Mr. Costello's house to see your daughter, you went to a hotel with your new boyfriend, true? True?
My daughter and Mr. Costello was out, for somebody's birthday party, and I'm not allowed to be on their family because their family is, not too friendly with me, so I decided to stay back and not go to that party.
But you could have went back to Mr. Costello's house, right?
I don't find it necessary for me to go back there when he has his family helping with her. I don't have to be at his house if I don't want to.
But you were living there.
Just because I'm living there does not mean I have to go, I have to be there 24/7.
Right, but you hadn't seen your daughter in over a week because you had been hospitalized.
She was already out, and I could not see if she was not at the house.
You know when she returned to the house?
Yes, I did.
When was it?
It was late at night,
Okay, and when did you return home? Not till the next day, right?
next morning.
Now, are you consistently taking your mental health medication?
I only take anxiety medication and depression medicine, and I no longer take it
Why?
because it is not helping.
Do you see a psychiatrist?
I do
Okay, and how often do you see that psychiatrist to have help with
once
you?
a month
When's the last time you saw them?
before I went into the hospital,
So so you're talking like 3-4 months ago.
back in 2024. I still see a therapist.
Where's your daughter going to Head Start at?
The Head Start program that he's come out to, was going out to Mr. Costello's house. When, Mr. Costello was at work, the ladies would come over. Sometimes they would come over when he got out of work, but half of the time, they would come over to his house when I was there with him.
Okay, and so she's been consistently doing that at his home, true?
Yes,
Okay, so how many people are living in this Ondale house?
me and my boyfriend.
You mentioned you had stuff for your daughter, true?
Correct.
It's also true that you picked it up in like the last 24, 48 hours, true?
No,
No?
no.
Okay. Do you receive assistance for yourself and the minor child?
Actually, I was living with my stepfather, yes.
Okay. So how do you intend on providing any type of basic, necessities for your daughter when being unemployed and receiving no assistance?
I am currently fixing up my new house. And, once the painting job is done, the furniture is in, I was going to start looking at jobs. I didn't want to put in any applications because I didn't know how far it was going to go, and I didn't want to start a new job working with court issues, well, not issues, but doing court stuff.
Okay, so what's held you back the last 9 months on getting a job?
Because I have anxiety, I have depression, because I have postpartum depression, and it really doesn't run with.
Okay, and so that would be the reason that for the dozens of times that you have.
It was not dozens of times.
I didn't finish my question there, but that the anxiety depression that you suffer with would be the reason that you had taken your child to her grandparents as well as her father a number of
Not
times.
the only reason. I had appointments, I had an EMDR treatment, and therapy appointments, doctor's appointments. I cannot take her to my EMDR treatments because I cannot keep my eyes on her because that kind of therapy is, I have to be focused and I have to be really into it. My attention cannot be on my daughter where I'm doing EMDR treatments.
So that's the therapy that you're currently engaged in.
EMDR treatment and regular therapy.
And you had mentioned that there was some issues with the trading some days and not sticking to the 2-2-3 schedule, true?
Yes.
And isn't it also true that it was because Mr. Costello asked you for some assistance to deal with the death of his mother at her funeral?
That is correct.
And it is correct.
I watched him.
Okay, that's,
And even when he was back home, he still needed my help with her, which is not, it's not part of the agreement.
Okay, so you don't believe that if someone else,
If he was to be fair and to, help me when I needed help, I would have not, had such an issue with it.
you don't think that putting a roof over your head, paying for your cell phone and your car insurance and providing for all your basic necessities is not helping you?
Mr. Costello he has paid the car insurance most of the time, but my cell phone did not always pay.
All right. Your Honor, I mean, I could go on and on all day. I'm just gonna leave it here, and if we need to continue, like I said, we can do that, but I know you have
All
a
right,
back.
thank you. Anything else you want to add? But I have to caution you though, miss, we have to look from 2/1/24 forward, not prior to that. We have to look at the order that was last entered on February 1st, 2024, moving forward. Anything you wish to add? Okay, you may step down.
Thank you.
Wish to call your witness.
Yes, I'm gonna call my phone, Your Honor.
Sir, please step up to the witness stand. You're under oath.
All right, Brent, I'm gonna just kind of go through a couple of things with you. As we've already went through, we're gonna go from February 2024, okay? So I need you to say yes or no, not okay, because I gotta keep a record, okay? So, in the last year, would you say that it is a true statement that Haley has forfeited her parenting time to you or your parents at least 40 different times?
Yes.
Excuse me, your name, please, for the record.
Brent Costello.
Thank you. Go ahead.
Sorry, Your Honor.
No, you're fine.
And to your knowledge, Haley has also resided in a number of different places over the last year, true?
Yes.
And in August of 2024, you allowed her to move back in with you, is that true?
Yes.
Because she was effectively homeless.
Yes.
Okay. And so you allowed her to live with you for approximately 7 months.
Yes.
And during that time, you were paying for almost all of her living expenses.
Yes.
And there were a number of times that it was her parenting time, but she's out and about with various significant others, true?
Yes.
And it was your responsibility to make sure that your daughter was cared for.
Yes.
And you make sure that she has everything she needs, is that true?
Yes.
And if the court were to modify the custody arrangement, you already have plans in place for your daughter, is that true?
Yes.
So you've already been working on potential daycares and things of that nature, is that true?
Yep.
And for your child's entire life, where you live has really been her home.
Yes.
And your living situation, that's a steady, permanent home. You're gonna be there for probably forever.
Yes.
And for the last year, you've spent a significant amount of time with Haley because you allowed her to live there, is that true?
Yes.
And would you agree that she's definitely struggled with her mental health?
Yes.
Is there concerns that she does not take her medication appropriately?
Yes.
And due to her issues with mental health, do you have concerns that your daughter will not be appropriately taken care of?
Yes.
You still want to be able to co-parent with Haley, right?
Yes.
And you, in the event that at some point she does take her medication like she's supposed to and she does become stable, you want her to be a more active part of your daughter's life, is that true? Would you say that it's fair that you did try over the last year very hard to work with her and to get her to a better place?
Yes.
Is that why you did things like paying 6 months of car insurance and things like that?
Yes.
And on top of that, during that time though, you were still like paying your child support, doing all of those things.
Yes.
So it's absolutely true. This isn't a money thing for you. You're just looking out for the best interest of your child.
Yes.
And you say you have a great relationship with your daughter.
Yes.
And you've been gainfully employed for how long?
Almost 13 years.
And you're doing well?
Same place, but yes.
So there are no concerns on your ability to be able to provide proper care for her, true?
Yeah, great.
Okay. And going back to, you had heard Haley discuss a few things about you forfeiting a couple of days. Do you remember that?
I don't recall that, no.
But there was a period of time where you had tried to reach an alternative agreement to where your daughter would stay with her for a few days that would have been off schedule, true?
Yes.
And that was due to the death of your mother.
Correct.
And then on the day of your mother's funeral, she was going back on that, like, I'm not helping you, it's your time, take care of it.
Correct.
Yeah, so. Do you believe that, the distance between where you currently live and now where she's living at in Ondo is gonna be feasible with the current, the 2-2-3 schedule?
No.
No. I don't think I have anything further.
Mr. Roca, do you have any questions of?
Yes, I do, Your Honor. I was wondering if I could also cross-examine Mr. Costello.
That's what I asked. So you may step up to the podium and ask the appropriate question.
Mr. Costello, I'm curious, you told, your lawyer that I did not help you, with your mother's passing, correct? You told her I wasn't.
I'll rephrase what I said. It was more of a struggle to get you to help. You did that one day, but then the following during the funeral, you gave her back earlier than what I was expecting. So you did help during the wait, but it was a struggle to get. It was a fight with you.
But I did help you the next day, right? And how long did I stay for?
For the funeral,
For
the
both
following
days.
days for the,
For
yes.
both days. How long did I stay with you to help you?
We almost stayed for the wait, I think 7 or 8 roughly, and then the following day, you brought her back, at the luncheon. So that was roughly 2:30. But I mean, you brought her back earlier than I expected, but.
And, you had said to your lawyer that you would like to co-parent with me. You would like to continue on.
I do, but I just want to make sure there's stability with you and you got your medication corrected and she's in a stable home and I can trust your partner and whatnot.
But you have said you wanted to co-parent, but you're wanting to take sole and physical custody away from me. So how is that trying to co-parent when you're trying to take away custody?
At this time, like I said, just once you get medication corrected and you have more stability in your life, get a job, and I know I can 100% trust you with our daughter and your boyfriend or the household, and you know there's more stability, not just be with somebody for a month and be like, yes, I can trust that person. No, there's got to be like, okay, they're together, and I know my daughter is going to be around this person for longer than a few months and not just someone else.
And I understand that, Mr. Costello. But one of your reasons, one of our agreements is that we were not going to drink on custody time. Now, did you or did you not break that rule?
I would say after my mother's passing, yes, because I struggled.
Did you
After my mother's
break
passing,
that rule when you were not supposed to drink on your parents'?
I'm gonna object, asked and answered, he just said he did. And I would ask that she stop talking over him because we also have to keep a record of this
I agree.
and let him answer the
Okay,
question.
sorry.
He did answer the question. He admitted to it. Go to your next question, please, and wait until the answer is complete. Go ahead.
Sorry, Harold.
No, you're fine.
I think that's all.
Okay. You may step down. Further proofs.
No, Your Honor, I don't have any further proofs. And again, again, my request would be that my client be awarded, sole physical and legal custody of the minor child who has every other weekend, year round, and holidays by the court guidelines. And if the court's willing to do that, even just temporarily, pending in front of the court. But I think that there's enough here on the record. The issue is the stability and being able to provide that constant support for the young child. She is so young. And it's Mr. Costello that's been doing that and providing that stability her entire life. And the only time that her mother has been able to provide any type of stability is because of Mr. Costello, who's essentially doing it for her. It is about the best interest of the child, and I believe that the factors all would be in favor of Mr. Costello during this.
But your prayer for relief asks for sole physical, doesn't say legal.
You're correct, and I would amend that right now, based off of the testimony that was heard, as she is, told the court of her struggles with anxiety and depression, and her unwilling, not seeing a psychiatrist and not taking the medication. Those are huge concerns, okay? That's not something that we really wanted to have to do. And you also heard testimony from Mr. Costello, this isn't something that we want to do forever. I mean, I can't tell you how much this has pained him to do it, but you have to do it in the best interest of your child, and that's what he's doing. So, and he will continue to do that. And once she's able to prove stability, prove that she can provide the proper care, custody, and, for the child as well as herself, it's going to be expanded, because Mr. Costello knows how important a mother's role is, but they have to be healthy and stable to have a positive impact on their child's life. We all know what having an unstable, whether it's an environment or mental health of a parent, can do to such a small child.
Thank you. Ms. Roca, your response.
Your Honor, I believe that I have had, either between his mother and I, have had the most awake time with her. Just because I have anxiety that has developed after going through a traumatic assault. I am still dealing with it. And I'm a trying mother that's here right now, trying to fight for my daughter, and I will until I'm no longer on this planet. I have put my money, hard working sweat into my daughter. I've taken her at 3 o'clock in the morning to the hospital when she's had ear infections. She's had UTIs. Mr. Costello said we should wait in the morning, but I insisted to take her right away. Just because I have anxiety does not mean I'm unsteady. I'm not a unsteady place for her to be at. If I have an issue, I used to take her to her grandparents' house for a couple of hours or a day or two. If there was something wrong, I took care of the issue so that she would not be in harm. Even if I did have anxiety, she's not going to be in harm. It's just anxiety. My mental health is not determined on what I do for my daughter. It's what I do for myself. I can take care of myself because I'm here right now, dressed up, hair put together. I'm all put together here, fighting to continue to do the 223. I would like to get full custody, but I want Brent, Mr. Costello, to be in her life because I have not once taken her away from him. And Your Honor, I feel like this has all started when I move out of his house and I'm no longer doing what he says. Behind closed doors, nobody knows and who anybody can really truly be. Mr. Costello is a good father when he is present and wants to be present. When he would do overtime at work, I would appreciate it that he did overtime. But then he would come home and I would be by myself taking care of her, feeding dinner, changing her, and all his responsibilities were to give her a bath. And I would put her to bed and I would wake up in the middle of the night and give her the bottle and put her back to sleep. Mr. Costello has helped sometimes with that. But
I'm going to object at this point because we just referenced the bottle. The child's older than that. This is from February of 2024. I understand that she's in full curve, but
Counsel, I agree. It's a student facts, not an evidence. So anything else to finish your argument?
I am a trying mother. Just because I have anxiety is no excuse to take her child away, my child away from me. I think it's going to hurt Brielle.
Thank you. All right. This is a motion filed by father for custody and modification of custodial time. Since February 1st, 2024, the party stipulated to an order regarding custody on a 2-2-3 basis. Joint legal, joint physical custody. The motion brought by Mr. Costello here is requesting a modification of that. And before the court can order, even consider a modification, there must be an establishment of, at least by preponderance of the evidence, one, either proper cause or change in circumstance. Based upon the testimony presented in this case and review of the motion filed in this case, the court finds that there is a change in circumstance since the entry of the last custody order, which was February 1, 2024. This court finds that conditions surrounding custody of the child, whichever could have a significant effect on the child's well-being, have materially changed. The testimony provided during the course of this hearing was prior to, during the course of this process, both mother and father were living together for a period of time. It appears that father was providing the financial support, which again, that doesn't mean that because he does the financial support, that's the end all, because providing care for a child is, as far as the court's concerned, equal. If you're working overtime, the other parent's working overtime to make sure the child's needs are being taken care of. I don't deny that. However, from what I've heard, according to the testimony, there are some significant mental health concerns. Testimony of mother herself that she does not take her medication anymore. She feels it doesn't help. But that is an issue for the court because, again, when you self-doctor and you make your own, and you have the right to make your own decision regarding your own mental well-being or your physical well-being, there is a history of mental issues, and that is concerning to the court. The fact that mother has moved out of the home, in and out, various homes throughout this time frame, and no stable housing indicates to the court that there is a change in circumstance by preponderance of the evidence. Now, regarding established custodial environment at this point, I don't have a lot of evidence regarding that, but it appears that at least up until the time that mother moved out, there is an established custodial environment with both parties. And this is just on an interim basis, by the way. And as it's with both parents, it must be by clear and convincing evidence. Now, the court has not heard evidence regarding all the factors of this case, and the court's not going to be able to pass judgment on all of them. But as to what I think is important is factor B, capacity and disposition of the parties to give the child love, affection, and guidance. Clearly, both parties can do so. However, with the mental health concerns, that favors father. The capacity C, or I should say part C, capacity and disposition to provide the child with food, clothing, medical care, other remedial care. That favors father as well based upon the testimony presented. Now, I'm not faulting mother for not working. Certainly she was working. She quit in November, but had no explanation as to how long she was even working there, which ties in with the mental health concerns. Factor D favors father. The length and time the child has lived in a stable, satisfactory environment, desirability of maintaining continuity. The child has been living primarily at father's residence. Our mother was residing there as well. She's moved out. She's moved into the Owendale area. Have no information regarding the housing. And clearly that also goes to factor E, the permanence of the existing or proposed home. Clearly, the permanence has been with father. That factor favors father as well. The factor G is also significant, the mental and physical health of the parties involved. The court has already made reference to the mental health concerns that have been presented. That favors father as well. As a result, based upon those factors alone on an interim basis, the court is going to order that the current parenting or the custodial schedule, parenting time schedule, will be modified. That is, the parties shall maintain legal custody. However, as to physical custody on an interim basis, father shall have physical custody of the minor child, that is. Mother shall have parenting time alternate weekends, Friday at 6, Sunday at 6. My question is, Mr. Costello first, when does the weekend begin? Does it begin today or does it begin next Friday at 6?
Friday.
Mr. Roca, we begin it next Friday?
Friday starts from break from the holidays.
Oh, it's spring break. Okay, that's right. That's a different schedule.
I don't know whose year it would be.
Sure.
Parties wish to start the weekend schedule next weekend. Mom is entitled to spend break.
Okay,
That's what it is.
okay,
So it begins next weekend because mom loves spring break.
okay.
Go ahead.
Your Honor, is it too late to have witnesses for people to speak for me?
At this point in time, it's based on it's preponderance of the evidence standard. And at this point in time, I'm standing by my order. But this is temporary. This is temporary. I'm ordering in front of the court investigation regarding custody, parenting time, and support in this matter. Otherwise, prior orders will remain in effect at this time.
So Your Honor, do I have to give her back today?
Yes,
Okay.
yes. That'll be all. Thank you.
The whole truth, nothing but the truth, so help you God.
I do. Thank you. Ms. Szymanski, this is your motion. Please stand and explain to the court what your position is and what you're requesting.
I'm requesting my dog back as she is an emotional support dog. I have had her for 13 years. I was through a traumatic car accident and I, in a sense, depend on her. She helps me with rehabilitation and she helped me get as far as I am today. As after the accident, I was labeled to be a vegetable for the rest of my life. And she has obviously helped with my recovery. I owe a lot of my recovery to her. My mother bought her as, I guess, a family dog for me to share, but she was bought overall for myself and my recovery.
Back on February 14, this motion was heard before the court, and not one time did you ever mention this animal as a support dog.
I understand, sir.
And then you present to the court information from your doctor
Yes, sir.
dated nearly a week later.
Yes, sir.
You can't do indirectly. You can't do indirectly what you're trying to do directly. This was never brought, you may be seated. This court was advised regarding this motion previously. Not once did the plaintiff bring that to the attention of the court. Not until after the court ordered this did Ms. Szymanski go to her doctor and get this letter.
Sir, I was
Sir,
under.
miss, I'm making my ruling. This request is denied. The dog is to be returned immediately if it hasn't been returned already. And frankly, this is a frivolous motion because it should have been brought, if it was something of significance, you would have brought that to the court's attention at the previous hearing. You did not do that. This is an end around to the court's ruling. The ruling, the motion is respectfully denied. Dog is returned. That'll be all off the record. This plaintiff's motion regarding communication, she is present. Mr. Willenius, the defendant is present as well. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. This is a motion regarding communication filed by Ms. Willenius. Again, we don't want to use the child's name, but actually it's Ms. Mitchell, correct? So I apologize for that. Ms. Mitchell, please stand and explain to the court what's going on here, what you're requesting.
Asking to review the case in regards to P. We have an agreement. And, we were supposed to meet for drop off. She had a dance party. I agreed to let her go to it and come later. At that time, I wasn't told anything. The dance had started. I was not aware that she had started. I had her for intercession. She was not sent or told to bring any of her dance gear. On Sunday night, she was called and told that she had dance. She was very upset and worried that she wouldn't be able to go because she didn't have her gear. later to find out she didn't want to go anyways, which helped me out because I driving 3 hours after working 8 hours in a day on Tuesday, after Sunday the 16th, February 16th. There's a lot of driving after working 8 hours and not having much notice to talk to work.
Okay,
So she was called by the defendant and told that she had danced on Tuesday, but was sent for intercession without any of her dance gear or with me having knowledge that she had danced that week even.
okay, so let's start from the beginning. First, how old is the child?
10.
10. Okay. Now, what is the parenting time schedule?
It's every other weekend, every other intercession, not every other weekend, I'm sorry, 3 weekends a month, every other intercession, and some are week to week. Holidays rotated.
And you have that schedule. Otherwise,
I have the weekends.
okay. So the time of these dancing lessons or
Dancing lessons.
okay.
And she was on intercession at that time. Sorry.
Okay, so who signed up the child for dance?
The defendant.
Okay. And during that time that the child was supposed to be in dance, is that your time?
At this point in time, it was this week.
Well, I'm talking about regarding this motion.
In general, her dance lesson is on his time,
Okay. So,
but she was there that week for intercession for break. They have all year schooling in Flint. So she's there for my week during intercession, our week during intercession.
so I guess I don't understand. She didn't have her gear?
She didn't have anything. I wasn't told the dance had even started by the defendant. Nothing was notified to me.
But it was his time though, right?
It was his time, but not for that week. That week I had her for intercession. So I should have been notified that I had engagements that I needed to fulfill.
So in essence, I have to interrupt, but is it the fact that you're alleging he didn't communicate regarding when dance was?
He didn't communicate with me.
Right. And you allege it was during your time.
Yes.
So I've seen you raise your hand countless times. You'll have your opportunity. Please be patient. What, and you're talking, this would have been February 16th?
Yes, sir.
I have to refer to the front next time.
So we would have to reference the school's actual calendar year, Your Honor, because it is a year-round school schedule. So it's not our typical September through late May, early June schedule that our local districts have. I believe their summer break is somewhere around 5 to 6 weeks.
Oh, I'm familiar with it. My daughter's.
They have those additional weeks off, so I would have to look at the calendar for that particular district.
But
Okay.
That was the second weekend, the 14th through 16th was the second weekend of February. Special weekend. I'm not sure if intercession started going into that week.
so it would have been her weekend, but we don't know. Is there something in the order regarding intersection?
Yeah, they alternate.
Okay, so, but you don't know whose intersection week that was.
I don't know.
But that would trump the weekend.
So yes, when this order was set up, Your Honor, it actually, when it started, it fell out perfectly that when they were rotating the intercessions, that the weekends that Ms. Mitchell had kind of would go into her intercession. And I believe just from hearing testimony this morning, that's what happened for February.
So it's probably, you're saying it could be likely her.
Correct, and in my understanding that it's a go-between being used, the piece being used as a go-between to relay information.
Correct.
And that was addressed in the judgment of force in October.
And she's not to be the go-between.
Correct.
Okay. Makes sense. Thank you. Okay, got it. So you're stating that the child is kind of the go-between here.
Yeah.
Okay. The parties are communicating by app close. And did you receive any messages regarding the dance schedule?
I did submit documentation to the court and.
No, I'm asking whether or not you received it from father regarding the dance schedule.
Oh, no, not at all.
Did not receive it. And so the essence of your motion is, hey, look, if there are dance lessons, whatever may be going on, I need to know what the schedule is.
Yes.
and not have the child be the intermediary.
Yes. and
That's your allegation.
Yes, sir.
Okay.
And she
Anything
should-
else I'm missing?
No, just that she should be sent with her gear if she has dance lessons, because she became frantic. And
Okay,
she didn't have anything,
okay, I got it.
and the dance party was more important, it appeared to me, than letting me know that she had dance lessons. So a dance party was, to me, is not more important than the lessons themselves. And I gave up 2 hours for her to go because she said she would like to go.
She wanted to go.
Right.
That makes
I
sense.
did it.
Okay. Dad, please state your response, please.
About the dance lessons, I enrolled her back in dance in October of last year. I spoke with Anna and asked her if that would be okay because some of the classes would interact with her timing. She agreed with it. At that moment in time, I let her know her dance lessons were Tuesdays at 5:30. That was in October of last year. She agreed with this. All I did was call Paxton to let her know that she still had dance and I was going to let her mom know.
Okay, what, could have been just simple to call mom and let her know?
I was about to let her know. I was letting them both know. I was calling Paxton to see if she had her dance
Okay,
gear.
please don't use the child's name, but. So there's a verbal discussion you claim regarding the schedule. But
It was in AppClose. We texted about it in AppClose in October.
okay, well, you said you told her.
We did at her first dance recital also
But my question is, was it entered in app close?
in October.
You're stating it was?
Yes, sir.
Okay. Okay. Anything else?
Well, I was just making sure. And the messages she printed off, it also doesn't state that I contacted her and said if she wasn't able to go, since I paid for these classes every single month and I paid for everything, that I didn't want her to lose her spot. So she needed to let me know. So I could contact the dance place and let them know that she wasn't gonna be there for that dance thing.
Okay, but if you want to make sure, and how old is your child again?
Okay,
10. Why wouldn't you just contact mother?
I did.
But then why did you have to contact the child?
I was seeing if she had her gear. She had her.
But wouldn't it be your responsibility to have the gear ready for her to take to mom's house?
She had her leotard, but I noticed she didn't have all of her shoes. I told her I would meet her there to drop them off. I also let Anna know this. I let Anna know if she wasn't able to get her to the class, I would have came, picked her up, took her to class, and dropped her back off to Anna the same day. Anna doesn't like to reform all of this information. Her and I have been in contact. Her and I do talk all the time about these dance classes, about the extras that go on with it, and about the stipulations that dance classes have. She has the number for the dance classes. She's met the instructors for the dance classes. She's had plenty of opportunity. If she has any questions, to ask them also, and she does not take any opportunity.
Do you use the app close calendar function?
I have not used it yet.
Okay. Okay, I think I've got it. Thank you.
You're welcome.
Final comment, please.
Dance resume, or
Please state.
dance, ended for the year, last year. This is the new year. It had not started yet. No lessons have been done for this year. That was last year's session.
Okay, I think I've heard enough. Appreciate it. You've heard the phrase before Houston, we have a problem. And that is being able to communicate. Sounds like the child's interested in the dance party. When it comes to dance classes, father enrolled. And it sounds like, though the parties do communicate with each other, it's not very clear as to, well, did you bring this? Did you bring that? Did you do this? Did you do that? She's a dance on Tuesday. She's a party on this day. The child should not be the go-between. Simply put, dad only needs to make sure that mom understands what the schedule is. Dad is responsible to make sure that if the child has a dance class or dance party, whatever it may be, that the gear goes with the child to mom's so that there are no issues. So I am going to order in this case that app close still continues But regarding the dance schedule, the parties are to utilize the at-close calendar function. We put it in there. It's clear as a bell. This is what's going on. Dad, make sure she has all her shoes, all her leotards, whatever she may need regarding this. And the child need not be contacted anytime forward because you'll make sure that you get it done. So in other words, you don't have to confirm with the child, you confirm with mother. That's it. That's it. So the motion in part is granted, in part denied, because at the end of this, when we have a failure to communicate, and there's an issue, contact the other parent, not the child. You're raising your hand, sir.
Yes, sir. Regarding these dance classes, I pay $112 a month, plus I pay for all the gear and everything else, which I have no problem doing. This is something my daughter enjoys. This is something she's voiced to Anna that she enjoys. This is the second class she has missed on Anna's time due to this. And I've let Anna know, this is a year-round thing. It goes all year round.
Okay, well, that's why you put it in the calendar.
I mean,
Put it in the calendar function and it's clear. I
eventually,
don't need to.
but what happens if she doesn't take her, my daughter gets kicked out of this class? I mean, just
Communicate with each other regarding that. Mr. Holman.
Just for clarification of the order, Your Honor, so the ruling is that essentially previous orders remain in effect because
Yes.
the original order, it specifically states at close and the calendar function.
Oh, I did order that.
Yes, as well as the child's not to be used as a go-between, no negative or creating comments, or standard communication with those two extra things
Okay,
added.
so I'm granting the motion.
So that was, again, like I said, the judgment of course ordered that already.
Already ordered it. Okay. Use the calendar function. That'll take care of all this.
yes, sir.
What's your question?
I want to know when the first class was that she was missed.
It was back in November, the first week she had her in
You can
November.
discuss that between the two of you.
Yes, sir.
And also, sir, fees insurance had been canceled by the state. I kept it on her as long as possible as part of the motion.
Oh, yes, I apologize. That's right. What is the issue with the medical?
The state had canceled it. She had, Michigan Healthy Kids.
You want a copy of the card, right?
No, as soon as I had found out the state had canceled it, I called to resolve it. They were told that she is primarily with him. They asked how many days she was with me, that he is responsible for her insurance. I've been paying medical this whole time when the state has been taking care of her medical, dental, and health.
Who provides the health insurance for the child?
I did the state did up until January.
So what are you asking?
I'm asking why I've been paying medical this whole time and that he take care of her medical due to the fact that the state says that
What are you paying in medical?
17 a month, I think I already, 32 or 17, I can't remember. For some reason, those two numbers are in my head. And if the state's taking care of it, then I don't know why anyone would be paying that.
I need some help from front.
I think it's 32.
The last support order that was effective August of 24 indicates that Ms. Mitchell had a healthcare premium adjustment of credit against the base support, and then ordinary medical was $17 per month. When a child's insured by Medicaid, that ordinary medical money is redirected back to the state of Michigan as reimbursement for that coverage because you don't have co-pays and deductibles. When a parent provides private health care coverage through an employer, you can have a credit in terms of the premium adjustment. It's not a dollar for dollar credit, but that's part of the child support calculation. But you always may have out-of-pocket expenses, and that is what medical support is used for if there's not Medicaid involved. And that's based on your percentages outlined in the support order. It's your monthly portion of the annual amount, which at the time your order entered was $454 per child.
So she's required to pay that.
Absolutely.
That's why.
And also I was told that he had gotten insurance on her. He will not provide me with her health insurance. This is all in the
With the card.
website.
Do you have a card for her?
I haven't received them yet. I'm still waiting on them. I told her I would give her the stuff when I receive it, and I haven't received it yet.
Do you have any indication when you'll be receiving your card?
They said it was in the mail. They said it could take up to 20 days.
So,
Friends of Prill will a copy of that as well, and we will forward it.
Yes, ma'am.
so send it to the friend.
Yes, sir.
And then you'll get a copy.
Can I bring up something about the insurance?
No, we've addressed it.
But the problem is with the communication again, sir.
Right, but no, we've addressed it.
But that dropped off in January and she didn't let me know until last week.
Sir, I know, but we've addressed it. We've addressed it. I'm not faulting you. I'm not faulting anyone.
But my daughter was without insurance for almost two and a half months because she didn't communicate. All she had to do was let me know it dropped off and I would have taken care of it a lot sooner and it would have been taken care of.
And this goes back to the failure to communicate. I'm over here, sir.
I know.
Yes. What am I missing?
And as soon as I found out, I called the state.
Okay, we're not going into the factual issues.
Okay. But he told me.
We're not gonna go tit for tat. We're not doing that.
In Expo.
Miss,
I
hold
can't
on.
have the card.
Time out. The court is in charge. You're not in charge.
Yes, sir.
Thank you.
Thanks.
The insurance has been applied for by father. The cards are quote unquote in the mail. Ms. Schultz will receive a card from Mr. Wallenius, which will be provided to you, and that addresses all these matters.
I do have the insurance, the number for the insurance, if the case number and everything, if she needs it.
I do not need it because we're linked into my birth.
You got it. Thank you.
You're all set. Thank you. Off the record.
Have a great weekend.
Spawn. This is the defendant's motion regarding custody. Both parties are present. Both please raise your right hands. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. This appears to be an initial determination because this began as a support matter provided through the prosecuting attorney's office. And in the order of support that was entered on February 27th, last month, there was support ordered on an interim basis. The court ordered joint legal custody, and on an interim basis, the court ordered physical custody to plaintiff, Mr. Gola, in this matter. And the plaintiff shall have sole physical custody of the minor children until the defendant requests a hearing and a front of the court investigation into custody and custodial time. And the order will stay in effect until such hearing comes before the court and the court makes their determination. So I'm assuming, Ms. Spahn, you are indeed requesting that to get this process moving forward,
Yes.
correct? Okay. All right, and the court had entered an interim order regarding the status of custody, physical and legal. Joint legal as to both parties, physical to father. And were you at the hearing originally back on February 24th?
It was over Zoom, but yes, I guess, kind of.
Okay, so what is the proper cause or change in circumstance since the last hearing?
At the last hearing, I was in jail, unfortunately.
Why were you in jail?
It was a long situation.
Is it a pending criminal charge or is it a criminal charge that's concluded? Is it a failure to pay on a ticket?
No, it was a situation with some friends. We all got locked up. We were all just drunk. It was really bad. And we all got locked up. I ended up walking away with a misdemeanor, everyone else with felonies.
What was the misdemeanor?
Assault and battery.
Upon child or?
No, another adult.
Okay, so.
Your Honor, I'm gonna just kind of stop that right there because I actually represent her in that matter with Scholar County. Yeah, so I would prefer her to not talk about anything like that. So.
Okay, well, I don't know what's going on.
I don't, yeah.
For the record, Ms. Jessica Risky stood up and made comment. Okay. So what's changed since February 24 that you believe that I should review the interim order?
Everything between me, I have, from being in jail, I have, and, oh my goodness, I'm sorry, I can't speak, I'm nervous.
And I require you to stand too as well.
Oh my gosh, I'm sorry.
I apologize.
I attend AA every Wednesdays just because alcohol was involved. I am sober off of everything. I don't do anything. I work all the time. I have a good job. I live currently with my mom, which doesn't sound good, but I have a great support system. I just think it's better that the kids have both parents in their lives instead of just one. I think it would benefit everyone involved for both parents to be involved in the children's lives.
Okay. Is there any parenting time at this point?
For me, no.
This is a motion regarding custody. Okay. Sir, your response.
Do I need to stand for it?
Yes, please.
I would like to keep and retain my full custody. Their living situation is not plausible. There is more than 7 people living in a 3-bedroom house. Their living room has been turned into essentially an Airbnb. There's mattresses for everybody to lay down on. They sleep in recliners and on the couch. Where I reside in Ubly, each individual kid has their own respective bedroom. I have my own respective bedroom. We rent out the entire upstairs of the house. There is no shared into groceries and stuff. Like I have my own. Well, I'm trying to think. It's providing. I provide for them all on my own. Like my roommate doesn't help with me. My dad and my little brother, our third-party contact, are the main babysitters for myself right now when I don't, or when I have to go out and do job interviews and stuff for work.
What are your thoughts about mom having a parenting time?
If she can do multiple months of the AA, because I know I have text messages proofs that she was drunk while caring for our son.
There are 3 children, correct? Two, sorry. Okay, but you're saying mother is not fit to have any parenting time with the child, even supervised?
Supervised, maybe, but not by herself, no.
If it were supervised, is there a supervisor that could monitor this?
My father.
What's your father's name?
Pat Gola.
Are you able to supervise it?
I have no contact order with her, so I would like to keep it like that.
What's the no contact order based on?
The domestic violence that we were supposed to have yesterday, but Judge Harrington wasn't here for the.
Oh, there's a charge of domestic violence?
Yeah.
And who's the alleged victim?
She is.
Who is the person alleged of committing the domestic assault?
I am.
But there's a no contact provision.
Yes, that she has broke multiple times.
Oh. I'm assuming front of the court has no third-party supervisors. They want to pay. Well, mom's working, she testified. Dad, are you working? You may be seeing.
Oh,
are you?
I have classes with Michigan Works to work on getting my CDLA. So that's what I'm.
But you're not working right now?
No.
What does it cost?
They're currently charging $25 an hour for mileage. I do have a very limited remainder of access and education grant funds left for September. I think we have $300 for a couple hours.
You have a proposed supervisor?
I do not.
Family member, close friend?
My mom isn't working right now, so she could.
What's her name?
Shanna Theaker.
How do you spell the last name?
Theaker.
You said Shannon?
Yep, no, SHANNA, Shanna.
Shanna, okay.
Sorry, it's common, happens a lot.
Are you familiar with Ms. Steeker?
Yes,
Any problems with Ms. Steeker?
yes.
What are the concerns?
She is very also mentally unstable. I've witnessed herself hit herself in the head when she ran out of weed. So she's an addict.
The domestic violence allegation, when is that going to be resolved? Is it a trial or a plea or a dismissal? Any ideas, sir?
Yesterday, Miss Weisenbaugh said that we were gonna move it for trial.
Ms. Weisenbach?
Yeah.
Ms. Risky, you represent Ms. Spahn on what type of matter?
I represent her in the Tuscola County matter, the assault and battery charge that she had alleged. But for the record, I want to make it very clear, I cannot give her any type of advice in this case at all.
I'm not asking for that. I just want to know who's the alleged victim?
It is not this party.
But if it's not, who is the alleged party? If you know.
I don't know. I mean, I can pull it up for you real quick.
No, but it involves somebody at least.
Correct.
An A and B charge.
Correct.
And that's why she was in jail before, back in February when the court had.
Yes, Your Honor, and an offer has already been extended to her for HYTA, so I'm assuming that there's not much that's gonna be coming of that. And the individual, there are two separate counts, Jaden Allard and Taylor Jones.
2 counts.
Correct.
First and foremost, thank you. The court is going to make a ruling at this point. The court is going to order a friend of the court investigation regarding custody, parenting time, and support. It's an initial determination. It's initial only because the current matter before the court was on an interim basis. At the time the court entered that, the defendant was in the Tuscola County Jail. Now I hear father is charged with domestic assault against mother. There's a no contact provision involved. This is a motion for custody. Prior orders are going to continue as previously stated regarding any parenting time for mother. I will require the parties within 21 days from today to submit names of individuals who could supervise the respective parental or parenting time for mother. Those names would be submitted to the friend of the court. And I need 3 names. If you only have one, I guess you only have one, but no disrespect regarding the parties here. Patrick Gola or Ms. Beaker should not be on the list because I need someone, frankly, that's impartial, that can just monitor the visits so that the children are safe and there's no protection of either party. In other words, if defendant's mother is the supervisor, there's the possibility of trying to protect any alleged problems. Same with Mr. Gold. 3 individuals, if you have 3, submit it to the front of the court within 21 days. If you fail to submit it within 21 days of the court, or we don't get it, then at that time, the court will deny the motion and continue the prior orders. That's all I can do. This is a mess. That'll be all. Thank you. I'll be here. DS, Brittany Nicole Shepard, Theodore Lee Davis III. This is a friend of the court show cause regarding Mr. Davis regarding a contempt hearing. Today's hearing is scheduled because it has been alleged that the show cause was previously scheduled on March 14th, which would have been last week, and Mr. Davis failed to appear. I believe the bench warrant was issued, correct?
Correct, body bond was set, Your Honor.
And can you give us an update regarding this?
Yes, so as court stated, we were last before the court on the 14th of March regarding show cause for communication and legal custody against Mr. Davis. There was complaints filed regarding violations of the communication provisions as well as legal custody. There was an order entered on October 11th, 2019 regarding communication, no negative or degrading comments or standard communication provisions. There was an order that was entered May 9th, 2019 that stated the parties had joint legal custody. And there was an order from September 10th, 2024 that allowed Mr. Davis to seek a second opinion regarding some medical treatment for the minor child. Those three orders all played into the complaint of the negative or degrading comments being used by Mr. Davis towards Ms. Schember. The complaint also alleged that Mr. Davis had went for that second opinion and then changed the doctors without prior discussion or agreement with Ms. Schember. The September 10th, 2024 order, Your Honor, also stated counseling for the minor child, and that if they were I'm sorry, not for the minor child, for the parties, but if they could not agree, they would submit names in front of the court office so the court would decide. The front of the court was bringing that to the court's attention last hearing because we received one name from Ms. Schember, but Deneen Gundin had list psychological, but no records in our file of a list of names from Mr. Davis, so that was asked to be brought up as well.
Well, I can address that right now. Both parties were required to do so. One party did, it would be Ms. Gundin.
Okay. Also, Your Honor, there was a complaint filed in front of the court office on March 10th by Mr. Davis. Reviewing that complaint, it appeared from the complaint that he was seeking a modification to the existing orders, and motions would have had to been filed. Due to him not appearing last week, a letter had gone out stating such that he would have to file a motion asking for the modification of the orders based upon what was stated in that complaint. And then, as stated, due to his failure to appear, the court issued a body bond. He contacted us Monday morning after court, and today's hearing was set to take care of that issue.
Okay. Regarding the complaint, March 10, 2025 complaint, I don't know what the complaint is about, sir, but you'll have to file motions. You understand?
File a complaint motion?
No, file a motion with the court, not with the friend of the court, with the court.
The complaint filed in front of the court office on March 10th was asking for modification of the existing orders, which motions need to be filed to have court orders modified.
I also was complaining about her comments to us, and I did talk to front of court about privacy of address. During that time, did call CPS on me.
Okay, well, time out. You said it was sent to an old address. What was the house number? You didn't have to get the full address. I just wanted the house number. But that's not your address? I
just recently moved.
Okay, and you let the friend of the court know of your address change, correct?
During all this, yes, it all happened simultaneously.
Mr. Davis called our office and updated his address verbally and was informed by myself as well as other staff that needed to be provided in writing before it could be changed. And that was not done until recently after the hearing last week.
That's your fault, sir.
Under circumstances, I'm just tired of being harassed by
I'm not talking about that. I'm talking about the address. So the friend of the court, just a moment, sir. Friend of the court is going to send any notice, or the court's even going to send any notice to your last known address. Previous court orders are in the file that any change of address or employment, any contact information, you must file with the friend of the court, and it must be in writing. And you didn't do that, did you?
Not later on, a couple days after.
A couple days after the note, yeah, after the hearing. Okay, this is a show cause though, right?
It was last week, correct? Yes, yes, Your
Okay.
Honor.
But not show cause for failure to appear.
No, it was show cause for alleged violation of the communication legal custody provisions. And due to a show cause failing to appear that the warrant had issued.
Okay. Well, court's going to recall the bench warrant. You may be seated, sir. Ms. Schember, what is the issue regarding the alleged negative communication? Please stand when you address it.
For the last, I want to say couple of years or even further back, he's been using the app close to harass me. Recently, since I got married, the last 2 years, he's been harassing my husband over app close and using negative and degrading manner. Any chance he gets, it'll always start off talking about Tayton, or I'm sorry, username, start off talking about our daughter, and then it quickly escalates into him harassing me. I provided with some of the very degrading messages he has sent. And since knowing about this court hearing, he has sent 3 additional very degrading messages.
What do you alleging he stated?
My husband's older than I am, and he has said, have fun wiping your husband's ass.
Oh, yes, I recall that. Yep, I do recall that. I did read that.
And talking about changing his diapers and just very, very degrading things.
Okay, what about the issues regarding a medical doctor?
So we were here, I believe, last year, or maybe it was earlier this year, regarding some medical concerns for our daughter.
Well,
and
the court ordered that he can seek a second opinion.
Yes. So
but it's alleged that he changed the doctor without your.
Yep, and he laughed about it, and I provided in front of court.
What, did he change the doctor?
Yep, he changed her doctor to his doctor, the one that he got a second opinion from, and he messaged me later on after I found out about this, and he said.
So you were notified of that?
Yes, my doctor or her doctor let me know when I called them.
After it was done?
Yes.
Not before?
Yeah, it was after it was done.
Okay.
And I got messages from Ted or Mr. Davis through AppClose. It looks like your doctor dropped her as a patient and then sent laughing emojis. But that's not at all what happened. It was that when he switched doctors, he switched to his doctor as her primary care physician.
Okay, I got it. You may be seated. Sir, how do you respond first regarding the alleged negative communication?
Well, from the letters I sent to the court, or to what she says, we just don't get along through this past 6-7 years. But
so do you acknowledge that you sent those messages?
Do I even send, actually, you like to send some messages? I send them all.
No, please hear my question. Did you send messages to Ms. Schember negatively regarding her marriage to another individual?
Yes.
And the diapers and all that?
Yes.
Okay, because I read them.
Yes.
So one asks, how is that in the best interest of the child?
It's not. It's all right after she rejected me to try to co-parent with her for counseling for what our daughter wants, which is one time dad. But through 6 and 7 years, she has rejected me throughout, which I had to take her to hearings or about schooling, where she went back and forth to schooling, and then with the doctors, which now she says I'm sneaky, but I just took her to the court-appointed second doctor, and their doctors found out and just dropped her. I guess I never even talked to her.
Okay, but so did you change the child's doctor without?
No, I just went up there, we did the appointment, and then she texted me later, which is in the app close text, saying, oh, what's going on? You need to do something about it. Why did you change your doctor? I said, I have no idea what you're talking about, but it sounds like they just dropped you. That's what I said.
With laughing emojis.
Wait. Yes, it's his turn. you're aware the court ordered that you could seek a second opinion. Okay, so is the child being treated with your doctor now?
Yes, I guess so,
You guess so.
because I guess her doctor dropped her. Our doctor said our child seems normal. So we'll follow.
Okay, I understand. Okay. Right, you may be seated, sir. This is a show cause. First, again, the bench warrant is recalled. Mr. Davis has appeared. Again, we have an issue regarding not only communication, but more importantly, animosity between the parties, which again, has no foundation in the best interest of the minor child involved. The court reviewed the communications, and clearly, this court finds that they are in violation of the court order, and this is a dispute, and I actually find that father acted absolutely in bad faith. Again, commenting about the mother's significant other, husband, has nothing to do with this child. As a matter of fact, it just causes more problems. So, as a result, court is going to order a $100 fine that must be paid no later than April 4th. Regarding the doctor issue, I see nothing in here that just the doctor barely dropped the child. Father may have sought a second opinion, but now the doctor has changed. Mother said she had no idea, nor was there any discussion between the parents of a mutual agreement, as the parties have joint legal custody, that should be done. Father acted in bad faith. $250 fine will be imposed. Again, that'll be due April 4, 2025. Word of advice to you, sir. If it has nothing to do with the child, don't bring it up as it pertains to mother or the child. If it involves the child, I get that. I understand that. You can share communication that way. That's how you co-parent. But when you engage in these activities, and I did see the emojis and the laughing and all that, that shows clearly bad faith. You did something that you should not have done. If this continues, it won't be a fine anymore. The court can issue jail time. On top of that, the court can decide that because the parties cannot agree, and if one party just decides that they're just going to do whatever the heck they want, then the court can order that one party have sole legal custody. I don't need to hear any further on it. We have a better understanding moving forward. Any decisions that need to be made regarding the medical needs of the child need to be done mutually. And if they can't be done mutually, don't take the law into your own hands. Come back to court, file the motion, the court will hear it.
May I add?
No, Ms. Schultz.
Just to confirm for the record, Your Honor, both sanctions are payable to the court office.
Correct. Correct.
I did agree to the doctor's, what to do with pay. We did agree that we'll just help her through what she's going through. That's what we agreed on.
Right, but there's no agreement regarding changing the doctor.
I didn't do that though. I just went to.
I find based upon the evidence that you did. I don't agree with you, sir. Chuck, Booker, Clockett, third. This is an appeal from a landlord-tenant decision on eviction. The appellant is present, Ms. Walden. The court has been advised that Ms. Jester Risky will be representing. Will you file appearance for the court?
I absolutely will. Yes, Your Honor. Like I said, it was just because it was after hours and I don't have staff on Fridays, but I let somebody know as soon as I could that I just figured it was the ease of the court.
Okay. Before we proceed in this matter, the court has been advised by court staff that your client had called the court regarding this matter and was absolutely rude to court staff. There is no justification for that. There is no need for that. And I'm just going to leave it at that.
Oh, can you tell me what this was, your Honor?
Yeah, I haven't.
I just.
Ms. McNames?
This calling some legal advice. Advice her to use machine. She was beyond rude.
When was that?
I thought
Yesterday?
it was assisting
Was this yesterday?
last week.
Last week.
Being rude about anything.
Okay,
I've
well,
passed
no.
judgment on, I just don't want that anymore. Now, Ms. Risky, under MCR 7.109B, the appellant is responsible for securing the filing of a transcript. I don't have a transcript. What's the status of that?
Well, Your Honor, as I said, I'm just got here. Also, and I completely understand it, but I don't even think the other individual was present.
But there's no brief. There's nothing. All there is a notice of hearing. There's a claim of appeal, and that's it. Nothing. There's a judgment that was entered.
Yes, Your Honor.
But as I understand it, according to the motion filed, plus the judgment from the judge prior didn't listen to my side barely and disregarded my evidence and didn't give me a proper amount of time to move out. I need a transcript.
Okay, we can order said transfer. The problem is, Your Honor, and this was a discussion that came up late yesterday and this morning when I had spoken with Walden. The problem is that this is a month-to-month tendency that was not provided proper notice with a notice to quit. The termination of tenancy was never.
I can't go into the matter.
I understand that. And so that is where this all had came in. And I said, I would hop in today because obviously as an pro per person, as we see this all the time, they do their best filing documents. The court cannot give legal advice. They absolutely cannot. So that is why I had said, I'm going to come in here today. So, I mean, I have no problem with, we can order said transcript, but I would like a stay of the eviction pending this process.
Denied. Denied. There's no motion for a stay. Nothing has been filed. The transcript has to be ordered. I can't order a stay on something I have no idea about. I'm denied that. You can file the request for transcript. Once the court receives the transcript and it's certified, then we can schedule this for oral argument.
You can file a transcript. I guess we'll have to do with that. Okay. I guess my concern is the other individual didn't show up. It was an improper legal eviction, but we'll have to take that civil remedy up with that individual.
And maybe so. I don't know, but I have nothing to rule upon. And the fact that he may not be here doesn't change the fact that I can't proceed without a transcript under MCR 7.109B.
Okay.
That'll be all.